Trump now faces a coordinated institutional demand so comprehensive that legal experts say escape routes have effectively been eliminated. On February 7th, three separate government institutions simultaneously issued binding orders requiring identical document disclosures within a unified 30-day timeline, creating what constitutional scholars are calling an unprecedented alignment of federal authority. And this is not merely another round of legal challenges that can be contested through traditional appellate procedures or delayed through procedural motions. This represents a deliberate synchronization of judicial, congressional, and executive branch enforcement mechanisms specifically designed to close every avenue that has previously enabled months or years of successful resistance to disclosure requirements. When a federal district court, a congressional oversight committee with bipartisan leadership, and the Department of Justice all demand production of the same financial records with identical deadlines and coordinated enforcement provisions, the situation has moved beyond ordinary legal disputes into territory that legal historians say has not been witnessed since the final days of the Watergate investigation. The strategic coordination among these institutions signals a fundamental shift in how the government apparatus responds to sustained resistance against lawful disclosure demands. Subscribe now because the institutional mechanics I am about to explain reveal why this particular moment represents such a significant departure from previous legal confrontations. The sequence of events that led to this coordinated action demonstrates careful planning across multiple branches of government. Federal investigators, congressional committees, and Justice Department prosecutors have been seeking overlapping sets of financial records for approximately 18 months, filing separate requests through their respective legal channels. Each institution faced identical delay tactics, including claims of executive privilege, attorney-client confidentiality, and arguments that the requests were overly broad or politically motivated. Each pathway forward had been contested through successive rounds of litigation and appeals that consumed substantial time and resources while producing minimal actual document disclosure. According to sources familiar with discussions among senior officials across these institutions, a strategic decision was made in late January to synchronize their efforts rather than continue pursuing parallel but uncoordinated tracks. The logic was straightforward. If each institution acts independently, legal teams can exploit differences in timing, jurisdiction, and procedural requirements to create conflicts that justify further delays. However, if all three institutions demand identical documents simultaneously with unified deadlines and complementary enforcement mechanisms, the traditional delay strategies become far less effective or entirely unavailable. The formal announcements came in rapid succession on February 7th. At 9 o'clock that morning, Judge Rachel Morrison of the United States District Court for the District of Columbia issued a comprehensive order requiring production of detailed financial records covering tax returns, banking transactions, and foreign business dealings spanning 7 years from 2017 through 2024. The order specified a 30-day deadline with escalating daily financial penalties beginning at $50,000 and doubling every 7 days for noncompliance. At 11 o'clock the same morning, the House Oversight Committee issued a bipartisan subpoena demanding the identical set of documents with the same 30-day deadline. The subpoena was signed by both the Democratic chairman and the ranking Republican member, representing a rare moment of genuine bipartisan cooperation on a matter involving the former president. The subpoena warned that failure to comply would result in immediate contempt of Congress proceedings and referral to the Justice Department for criminal prosecution under federal statutes that make defying congressional subpoenas a criminal offense punishable by imprisonment. At 2 o'clock that afternoon, the Department of Justice, through the U.S. Attorney's Office for the Southern District of New York, issued a grand jury subpoena for the same financial records with an identical 30-day deadline. The subpoena was accompanied by a letter from prosecutors stating that the requested documents are material to an ongoing criminal investigation and that any attempt to destroy, alter, or conceal responsive documents would constitute obstruction of justice, a federal felony carrying substantial prison sentences. Legal analysts immediately recognized the strategic significance of this coordinated timing. Professor David Chen, a Harvard Law School expert in federal criminal procedure who previously served as an assistant attorney general, told national news organizations that the synchronization eliminates the jurisdictional conflicts and procedural inconsistencies that have enabled successful delay tactics in previous cases. When a party faces identical demands from a federal court, Congress, and criminal prosecutors simultaneously, the standard approach of playing different forums against each other becomes impossible. Appealing the court order does not affect the congressional subpoena. Challenging the congressional subpoena does not impact the grand jury process. Contesting the grand jury subpoena has no bearing on the court-ordered deadline. The enforcement mechanisms are designed to be mutually reinforcing rather than duplicative. The court order imposes escalating financial penalties that make non-compliance economically devastating within weeks. The congressional subpoena creates potential criminal liability under contempt statutes that could result in prosecution and imprisonment. The grand jury subpoena triggers obstruction of justice exposure if there is any indication that responsive documents are being concealed or destroyed. Taken together, these three enforcement pathways create what legal scholars are describing as an escape-proof framework where resistance to any single demand still leaves the target exposed to severe consequences from the other two institutions. Former federal prosecutor Jennifer Matthews, who handled complex financial fraud investigations during 15 years at the Department of Justice, explained to reporters that this type of institutional coordination is extremely rare and typically reserved for cases where targets have demonstrated a sustained pattern of resistance to lawful authority. The decision to synchronize enforcement actions across judicial, legislative, and executive branches reflects a collective determination that standard procedures have been exhausted and that extraordinary measures have become necessary to vindicate the rule of law. Trump's legal team responded with immediate public statements characterizing the coordinated demands as a politically motivated conspiracy designed to harass and intimidate. Lead attorney John Harrison held a press conference on the afternoon of February 7th, asserting that the simultaneous issuance of three identical demands from different institutions proves that this is coordinated political persecution rather than legitimate legal process. He announced plans to file emergency motions seeking stays of all three demands and to appeal the court order to the United States Court of Appeals for the District of Columbia Circuit. However, legal experts who reviewed the enforcement provisions say that appeals are unlikely to prevent the 30-day deadline from taking effect. Federal appellate courts have established precedent holding that stays of district court orders are granted only when the appealing party demonstrates both a likelihood of success on the merits and irreparable harm that cannot be remedied after the appeal is decided. In this case, the district court already considered and rejected every legal argument through 18 months of prior litigation, making a showing of likely success extremely difficult. Furthermore, the harm from producing documents in response to lawful subpoenas is not considered irreparable because if an appellate court later determines the disclosure was improper, that error can be remedied through protective orders or other post-production mechanisms. The congressional subpoena presents even fewer opportunities for delay through legal challenges. The Supreme Court has consistently held that congressional committees have broad authority to demand documents relevant to legitimate legislative functions, and that claims of privilege must give way when Congress is investigating potential misconduct or considering legislative reforms. The bipartisan nature of this particular subpoena makes arguments about partisan overreach particularly difficult to sustain. When both parties on a committee agree that documents are necessary for their oversight responsibilities, courts have historically been extremely reluctant to second-guess that determination. The grand jury subpoena operates under different rules that provide even less opportunity for pre-enforcement challenges. Federal law prohibits disclosure of grand jury proceedings, which means that targets typically cannot even confirm or deny the existence of a grand jury investigation, much less challenge subpoenas in public court proceedings. The proper procedure is to comply with the subpoena and then raise any legal objections during subsequent proceedings if criminal charges are filed. Refusing to comply with a grand jury subpoena based on legal objections that have not been presented to and rejected by a court constitutes contempt, which prosecutors can charge as a separate criminal offense. This multi-institutional framework creates what legal analysts are calling a compliance funnel, where every path leads to the same outcome. Complying with the court order means producing documents that also satisfy the congressional subpoena and the grand jury demand. Complying with the congressional subpoena means producing documents that also satisfy the court order and the grand jury demand. Complying with the grand jury subpoena means producing documents that also satisfy the court order and the congressional subpoena. There is no scenario where documents can be withheld from one institution while being produced to another because all three are demanding identical records. The strategic brilliance of this coordination becomes even more apparent when examining the specific enforcement timelines. The court order imposes financial penalties beginning on day 31 that start at $50,000 and double every 7 days. By day 44, the daily penalty reaches $1,600,000. By day 58, the daily penalty exceeds $100 million. This escalation makes prolonged resistance economically catastrophic regardless of personal wealth. The congressional subpoena operates on a parallel timeline. The House Oversight Committee has announced that if the 30-day deadline passes without full compliance, the committee will immediately hold a contempt vote that could occur as soon as March 10th. Once the full House votes to hold someone in contempt of Congress, the matter is referred to the U.S. Attorney for the District of Columbia with a statutory obligation to present the case to a grand jury. Criminal contempt of Congress carries a penalty of up to 1 year in prison and a fine of up to $100,000 for each act of contempt, with each withheld document category potentially constituting a separate offense. The grand jury subpoena creates additional criminal exposure through obstruction statutes. Federal law makes it a crime to knowingly withhold, conceal, or destroy documents that have been subpoenaed in a grand jury investigation. Prosecutors made clear in their accompanying letter that they will construe any failure to produce responsive documents by the 30-day deadline as potential evidence of obstruction, particularly if there are indications that relevant records exist but are being deliberately withheld. Obstruction of justice charges carry maximum sentences of 20 years in prison for each count. Taken together, these enforcement mechanisms create overwhelming pressure to comply. The financial penalties alone make resistance unsustainable beyond a few weeks. The criminal exposure from both congressional contempt and obstruction charges creates personal liberty stakes that go far beyond monetary considerations. The reputational damage from being held in contempt by Congress or indicted for obstruction adds another layer of consequence that affects political viability and public standing. Legal historians note that this type of coordinated institutional response has precedent in only a handful of cases, most notably during the final stages of Watergate, when courts, Congress, and prosecutors simultaneously demanded White House tapes that President Nixon had been withholding. In that case, the Supreme Court issued a unanimous decision ordering immediate production. The House Judiciary Committee was simultaneously proceeding with impeachment articles based partly on the refusal to comply with subpoenas. The special prosecutor had obtained grand jury subpoenas for the same materials with warnings that non-compliance would constitute obstruction. Faced with this unified institutional demand, Nixon produced the tapes, which contained the smoking gun evidence that forced his resignation within days. The current situation parallels that historical moment in significant ways. Multiple institutions have exhausted standard procedures over an extended period. Legal arguments for withholding documents have been considered and rejected through proper channels. The decision has been made to synchronize enforcement rather than continue with uncoordinated parallel efforts. The enforcement mechanisms are designed to make resistance untenable through a combination of financial penalties, criminal exposure, and political consequences. Trump's advisors now face a decision with no attractive options. Full compliance means producing 7 years of detailed financial records that may contain evidence of tax fraud, bank fraud, insurance fraud, or illegal foreign payments that have been the subject of investigation across multiple jurisdictions. Those documents could provide prosecutors with evidence to support criminal indictments or give congressional committees ammunition for public hearings that could prove politically devastating. However, continued resistance carries consequences that may prove even more severe. The escalating financial penalties will reach levels that cause serious economic harm within weeks. Criminal contempt charges would create the extraordinary situation of a former president being prosecuted for defying Congress. Obstruction charges based on grand jury subpoena defiance would add federal felony counts that carry substantial prison sentences. The cumulative effect of these enforcement actions would dominate news coverage and political discourse in ways that could prove more damaging than whatever the documents themselves might reveal. Legal experts across the political spectrum agree that the coordination among these three institutions represents a watershed moment in how government responds to sustained resistance against lawful authority. Professor Robert Thompson, a conservative legal scholar who has frequently defended expansive executive privilege claims, acknowledged in a television interview that when federal courts, Congress, and prosecutors all independently determine that identical documents must be produced and then coordinate their enforcement timelines, the legal system is sending an unmistakable message that the time for delay has ended. The 30-day timeline means that by March 9th, either comprehensive financial disclosure will have occurred or the most severe enforcement mechanisms will be triggered simultaneously across all three institutions. Appeals can certainly be filed, but precedent suggests they will not prevent the deadline from taking effect. Public attacks on the legitimacy of the demands may satisfy political supporters, but they do not constitute legal defenses recognized by courts or Congress. The institutions have aligned, the enforcement mechanisms are in place, and the timeline is moving forward regardless of political preferences or legal objections. This institutional alignment sends a broader message about the functioning of constitutional democracy. When courts, Congress, and prosecutors independently conclude that disclosure is required by law and then coordinate to ensure enforcement, the system is demonstrating that legal obligations ultimately cannot be avoided through wealth, political power, or prolonged resistance. The rule of law depends on institutions having effective tools to compel compliance when standard procedures have been exhausted and when targets have demonstrated unwillingness to comply voluntarily. The coming days will reveal whether these coordinated institutional demands succeed in compelling disclosure or whether resistance continues despite the severe consequences. What is already clear is that three separate branches of government have determined that this moment requires unified action. The escape routes have been systematically closed. The enforcement mechanisms have been carefully calibrated to make non-compliance unsustainable. And the 30-day countdown has begun toward what may prove to be a defining test of whether institutional authority retains meaning when applied to the most powerful individuals in American society.